Negligence. Concept. Every person criminally liable for a felony is also civilly liable. The revised Penal Code of the Philippines defines felonies, delitos, as acts and omissions punishable by law. Felonies are committed not only by means of deceit, dolo, but also by means of fault, culpa. There is fault when the wrongful acts results from imprudence, negligence, lack of foresight, or lack of skill. In the new Civil Code of the Philippines, whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict. It further provides that the fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. The Supreme Court has historically used common law definitions of negligence. 1. Negligence is want of care required by the circumstances. And 2. Negligence is the omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or the doing of something which a prudent and reasonable man would not do. An actionable negligence may be culpa contractual, culpa aquiliana, or criminal negligence. Thus, an action for damages for negligent act of the defendant may be based on contract, quasi-delict, or delict. The bases for liability are separate and distinct from each other even if only one act is involved. Culpa contractual. Negligence is merely incidental to the performance of an obligation already existing because of a contract. While in culpa aquiliana, negligence here is direct, substantive and independent. And also in culpa criminal, negligence here is direct, substantive and independent of a contract. In culpa contractual, there is a pre-existing obligation, a contract either express or implied. While in culpa aquiliana, there is no pre-existing obligation, except of course the duty to be careful in all human actuations. And also in culpa criminal, there is no pre-existing contract, except the duty to never harm others. For culpa contractual, proof needed, preponderance of evidence. Also for culpa aquiliana, proof needed, preponderance of evidence. However in culpa criminal, proof needed in a crime, proof of guilt beyond reasonable doubt. For culpa contractual, defense of a good father of a family, in the selection and supervision of the employees is not a proper and complete defense in culpa contractual, though it may only mitigate. But for culpa aquiliana, defense of a good father of a family, is a proper and complete defense, insofar as employers or guardians are concerned, in culpa aquiliana. This is not a proper defense in culpa criminal. Here, the employee's guilt is automatically the employer's civil guilt, if the former is insolvent. In culpa contractual, as long as it is proved that there was an existing contract and that it was not carried out, it is presumed that the debtor is at fault, and it is his duty to prove that there was no negligence in carrying out the terms of the contract. In culpa aquiliana, ordinarily, the victim has to prove the negligence of the defendant. This is because his action is based on the alleged negligence of the defendant. However in culpa criminal, accused is presumed innocent until the contrary is proved, so the prosecution has the burden of proving the negligence of the accused. By jumping into the sea, the employee failed to exercise even slight care and diligence and displayed a reckless disregard of the safety of his person. His death was caused by his notorious negligence. Notorious negligence has been held to be tantamount to gross negligence, which is want of even slight care and diligence. Elena Amedo vs. Rio y Olabarrieta, Incorporated. GR number L6870, May 24, 1954. Facts: on May 27, 1949, at about 11:30 o'clock in the morning, while the said Filomeno Managui was in the course of his employment, performing his duties as such ordinary seaman on defendant's M.S. Pilar 2, which was anchored then about 1.5 miles from the seashore of Archeli Dumarang, Palawan, his 2-peso bill was blown by the breeze into the sea, and in his effort to retrieve the same from the waters he was drowned. The plaintiff Elena Amedo instituted a case which sought to collect from defendant Rio y Olabarrieta, Incorporated, compensation for the death of her son, Filomeno Managui, who worked for the defendant as a seaman of the M.S. Pilar 2. Issue: whether or not Filomeno Managui was negligent. Ruling: yes, Filomeno Managui was negligent. Notorious negligence has been held to be tantamount to gross negligence, which, in turn, has been defined as want of even slight care and diligence. Here, Filomeno jumped into the sea, 1.5 miles from the seashore, to recover a fallen 2-peso bill, was an open and reckless disregard of one's safety, and the resulting death was undoubtedly caused by notorious negligence. Bar questions. 1. Spouses Diang sued GSIS for failure to return their title which they mortgaged in favor of GSIS, as it was lost, after the obligation was satisfied. GSIS said that it is not liable for the negligent act of its employee acting within the scope of his assigned tasks, since GSIS is a government-owned and controlled corporation performing governmental functions. Further, GSIS said that it falls within the term «state» under Article 2180(6) of the NCC, and cannot, therefore, be held vicariously liable for negligence committed by its employee acting within the scope of his functions. Decide the case. Answer: in the GSIS versus Spouses Diang case, the court held that there was a pre-existing contract between the parties. GSIS and the Spouses Diang had a loan agreement secured by a real estate mortgage. The duty to return the owner's duplicate copy could not be returned to the owners. Article 2180(6) of the new Civil Code is not applicable, although GSIS is liable for damages because of negligence. The more applicable provisions are Articles 1170 and 2201. Since good faith is presumed and bad faith is a matter of fact which should be proved, GSIS can be treated as a party who defaulted in its obligation to return the owner's duplicate copy of title. As an obligor in good faith, GSIS is liable for all the natural and probable consequences of the breach of the obligation. The inability of the spouses Diang to secure another loan and the damages they suffered thereby has its roots in the failure of the GSIS to return the owner's duplicate copy of the title. In case of fraud, bad faith, malice or wanton attitude, the obligor shall be responsible for all damages which may be reasonably attributed to the non-performance of the obligation. 2. In January 2018, Mrs. A married woman on her 6th month of pregnancy, was crossing a street when she was suddenly hit by a car being recklessly driven by Mr. X. As a result, Mrs. A sustained serious injuries and further, suffered an unintentional abortion. Mrs. A was hospitalized for 2 months, during which she incurred 400.000 pesos in medical fees. Her expenses were all duly substantiated by official receipts. During the 2-month period of her confinement, she was unable to report for work and earn any salary, which was established at the rate of 50,000 pesos per month. Mrs. A then filed a civil case for damages against Mr. X based on the case filed by Mrs. A. What is the source of Mr. X's obligation to her as a result of his acts? Explain. Suggested answer: Mr. X's obligation arose from a quasi-delict, one of the 5 sources of obligations. The Code also provides that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done, and such fault or negligence is called a quasi-delict. Here, Mr. X, in recklessly driving a car, hit Mrs. A, thereby causing serious injuries and unintentional abortion to the latter. Number 2. Good father of a family or reasonably prudent person. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. The general standard of test is bonus pater familias, or that of a good father of a family. Pursuant to Article 1173, the diligence of a good father of a family is the standard of conduct if the law or contract does not provide otherwise. Diligence of a good father of a family means an ordinary care. Just like a father of a family, it is a care that an average person would do in taking care of his property. Anyone who acts below this standard is considered negligent. A good father does not abandon his family. He is always ready to provide and protect his family. The loss of things while in the custody of the obligor but without negligence or fault on his part, does not make him liable therefore. OMC carriers versus Nubuah spouses. GR number 148974, July 2, 2010. Facts. Petitioner OMC Carrier owned an Isuzu private tanker which was driven by its employee Jerry P. Lucas. While making a turn, said tanker hit the right side of the vehicle driven by the 18-year-old victim, who was the child of respondent Nubuah. He was mortally wounded by reason of the collision, resulting in his death. The Nubuahs filed a case with the RTC for damages. After trial, the court found OMC and Lucas liable for damages. Both respondents appealed the decision before the Court of Appeals, which eventually affirmed the RTC decision. Issue: whether or not OMC exercised due diligence in hiring Lucas. Ruling: no, OMC have not exercised due diligence in hiring Lucas. The court partially granted the petition for certiorari and reduced the amount of the damages awarded to the spouses. Also, the court determined that the proximate cause of the death of the victim was the negligence of the driver Lucas. Further, the court did not find any reason to disturb the findings of the lower courts. On the defense that OMC exercised due diligence in hiring the driver, the court said that OMC failed to overturn the presumption of negligence on the part of the employer. Article 2180 of the new Civil Code provides, employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The responsibility treated in this article shall cease when the persons herein mentioned prove they observed all the diligence of a good father of a family to prevent damage. It is then the burden of the employer to prove that it exercised due diligence. Reasonably prudent person, case, Picard versus Smith, Jr. GR number, L12219, March 15, 1918. Facts. Plaintiff Picard was riding on his pony over said bridge. Before he had gotten halfway across, defendant Smith approached from the opposite direction in an automobile. As the defendant neared the bridge, he saw a horseman on it and blew his horn to give warning of his approach. He continued his course, and after he had taken the bridge he gave 2 more successive blasts, as it appeared to him that the man on horseback before him was not observing the rule of the road. Seeing that the pony was apparently quiet, the defendant, instead of veering to the right while yet some distance away or slowing down, continued to approach directly toward the horse without diminution of speed. The horse fell and its rider was thrown off with some violence. As a result of its injuries, the horse died. The plaintiff received contusions which caused temporary unconsciousness and required medical attention for several days. Issue: whether or not defendant Smith was guilty of negligence such as gives rise to a civil obligation to repair the damage done. Ruling: yes, the law considers what would be reckless, blameworthy, or negligent in the man of ordinary intelligence and prudence and determines liability by that. The question as to what would constitute the conduct of a prudent man in a given situation must of course be always determined in the light of human experience and in view of the facts involved in the particular case. Conduct is said to be negligent when a prudent man in the position of the tortfeasor would have foreseen that an effect harmful to another was sufficiently probable to warrant his foregoing conduct or guarding against its consequences. Here, the court held that Smith was also negligent. And in such case the problem always is to discover which agent is immediately and directly responsible. It will be noted that the negligent acts of the two parties were not contemporaneous, since the negligence of the defendants exceeded the negligence of the plaintiff by an appreciable interval. Under these circumstances, the law is that the person who has the last fair chance to avoid the impending harm and fails to do so is chargeable with the consequences, without reference to the prior negligence of the other party. Bar question. Defense. Due diligence in selection, 2003. As a result of a collision between the taxicab owned by A and another taxicab owned by B, X, a passenger of the first taxicab was seriously injured. X later filed a criminal action against both drivers. May both taxicab owners raise the defense of due diligence in the selection and supervision of their drivers to be absolved from liability for damages to X? Reason. Suggested answer. It depends. If the civil action is based on a quasi-delict, the taxicab owners may raise the defense of diligence of a good father of a family in the selection and supervision of the driver. If the action against him is based on culpa, contractual or civil liability arising from a crime, they cannot raise the defense. Number 3. Standard of care. Emergency rule. Standard of care is an essential concept in determining whether a person was negligent and potentially liable for a tort. If a person breaches the standard that applies to them and their actions cause harm to another person, they will be liable for negligence. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard. Thus, it is possible for the parties to stipulate a different standard of care than the default, i.e. good father of a family. Operators of motor vehicles. In relation to cyclists. In the case of Nuisance versus CA, the court held that because of the inherent differences between motorists and cyclists, the former being capable of greater speed and destruction, operators of motor vehicles have a higher standard in his duty of care. Banks. In the case of Consolidated Bank versus CA, the court held that the law imposes on banks high standards in view of the fiduciary nature of banking. Section 2 of RA 8791, which took effect on 13 June 2000, declares that the state recognizes the fiduciary nature of banking that requires high standards of integrity and performance. This fiduciary relationship means that the bank's obligation to observe high standards of integrity and performance is deemed written into every deposit agreement between a bank and its depositor. The fiduciary nature of banking requires banks to assume a degree of diligence higher than that of a good father of a family. Experts. In general, in the case of Far Eastern Shipping versus CA, the court held that those who undertake any work calling for special skills are required not only to exercise reasonable care in what they do but also possess a standard minimum of special knowledge and ability. In all employments where peculiar skill is requisite, one who offers his services is understood as holding himself out to the public as possessing the degree of skill commonly possessed by others in the same employment. Doctors. In the case of Cruz versus CA, the court held that whether or not a physician has committed an inexcusable lack of precaution in the treatment of his patient is to be determined according to the standard of care observed by other members of the profession in good standing under similar circumstances, bearing in mind the advanced state of the profession at the time of treatment of present state of medical science. It is in this aspect of medical malpractice that expert testimony is essential to establish not only the standard of care of the profession but also that the physician's conduct in the treatment and care falls below such standard. Pharmacists. In the case of U.S. versus Pineda, the court held that the profession of pharmacy, it has been said again and again, is one demanding care and kill. Even under the first conservative expression, ordinary care, with reference to the business of a druggist, must be held to signify the highest practicable degree of prudence, thoughtfulness, and vigilance. Possessors of extremely dangerous instrumentalities. In the case of Patches versus Morales, the court held that a higher degree of care is required of someone who has in his possession or under his control an instrumentality extremely dangerous in character, such as dangerous weapons or substances. Such person in possession or control of dangerous instrumentalities has the duty to take exceptional precautions to prevent any injury being done thereby. Unlike the ordinary affairs of life or business which involve little or no risk, a business dealing with dangerous weapons requires the exercise of a higher degree of care. Children. In the case of Taylor versus Manila Railroad, the court held that take into account the specific characteristic of the child in question. The conduct of an infant of tender years is not to be judged by the same rule, which governs that of an adult. The care and caution required of a child is according to his maturity and capacity only, and this is to be determined in each case by the circumstances of the case. Age brackets, standard. In the case of Wilard versus Aquino, the court held that measure the acts of the child against average conduct of persons his age and experience. The degree of care required to be exercised must vary with the capacity of the person endangered to care for himself. The standard of conduct to which a child must conform for his own protection is that degree of care ordinarily exercised by children of the same age, capacity, discretion, knowledge and experience under the same or similar circumstances. Emergency rule. Emergency rule provides that an individual who suddenly finds himself in a situation of danger and is required to act without much time to consider the best means that may be adopted to avoid the impending danger, is not guilty of negligence if he fails to undertake what subsequently and upon reflection may appear to be a better solution, unless the emergency was brought by his own negligence. Case: Escander vs. Court of Appeals. Facts: a blue Toyota Tamaroa which was owned by defendant Sheila Sayan and which was driven by Edwin Aran encountered a head-on collision with an Isuzu pickup which was driven by defendant Rogelio Escander. In attempt to avoid the pickup, Sayan shouted at Aran to swerve to the left, but the Escander also swerved to its right, hitting the Tamaroa at its right front passenger side, causing its head and chassis to separate from its body. Eventually, Sayan was thrown out of the Tamaroa and landed on a rice field. Both Aran and Sayan were brought to Baratac Nuevo Medical Hospital. Sayan suffered a fracture on the right femur, lacerated wound on the right foot, multiple contusions, abrasions, blunt abdominal injury, and lacerations of the upper-lower pole of the right kidney. Upon discharge, Sayan incurred 130,000 pesos in medical expenses, while the Toyota Tamaroa ended up in the junk shop totaling a loss of 80,000 pesos. Issue: whether or not under the emergency rule Aran should be held liable. Ruling: no, Aran should not be held liable. Under the emergency rule, an individual who suddenly finds himself in a situation of danger and is required to act without much time to consider the best means that may be adopted to avoid the impending danger, is not guilty of negligence if he fails to undertake what subsequently and upon reflection may appear to be a better solution, unless the emergency was brought by his own negligence. Here, Escander's negligence was the proximate cause of the collision when he abandoned his lane. He did not see to it first that the opposite lane was free of oncoming traffic and was available for a safe passage, and after seeing the Tamaroa jeepney ahead, he did not slow down. Thus, Aran cannot be faulted. Bar question: a driver of a bus owned by Company Z ran over a boy who died instantly. A criminal case for reckless imprudence resulting in homicide was filed against the driver. He was convicted and was ordered to pay 2 million pesos in actual and moral damages to the parents of the boy, who was an honor student and had a bright future. Without even trying to find out if the driver had assets or means to pay the award of damages, the parents of the boy filed a civil action against the bus company to make it directly liable for the damages. Will their action prosper? Suggested answer: yes, the action will prosper. The liability of the employer in this case may be based on quasi-delict and is included within the coverage of independent civil action. It is not necessary to enforce the civil liability based on culpa aquiliana that the driver or employee be proven to be insolvent, since the liability of the employer for the quasi-delicts committed by their employees is direct and primary, subject to the defense of due diligence on their part.
4. Unreasonable risk of harm. Negligence, as it is commonly understood, is a conduct that creates an undue risk of harm to others. For example, if a driver of a vehicle recklessly drove his vehicle, thereby causing damage to another's vehicle, the reckless driving created an undue risk that resulted in such damage. Of course, driving without recklessness also involves risks. The moment a driver gets out of his garage, there exists a risk that somebody might be injured. Indeed, all actions entail a degree of risk and all conduct under certain circumstances may be a source of damage. However, in negligence, risk means a danger which is apparent, or should be apparent, to one in the position of the actor. Such type of risk is unreasonable risk. If such unreasonable risk results in injury to the plaintiff, the latter can recover from the defendant. Circumstances to be considered in determining whether an act is negligent. 1. Person exposed to the risk. A higher degree of diligence is required if the person involved is a child. 2. Emergency. The actor confronted with an emergency is not to be held up to the standard of conduct normally applied to an individual who is in no such situation. 3. Social value or utility of action. Any act subjecting an innocent person to unnecessary risk is a negligent act, if the risk outweighs the advantage accruing to the actor and even to the innocent person himself. 4. Time of the day may affect the diligence required of the actor. A driver is required to exercise more prudence when driving at night. 5. Gravity of the harm to be avoided. Even if the odds that an injury will result are not high, harm may still be considered foreseeable, if the gravity of harm to be avoided is great. 6. Alternative cause of action. If the alternative presented to the actor is too costly, the harm that may result may still be considered unforeseeable to a reasonable man. More so if there is no alternative thereto. 7. Place. A man who should occasion to discharge a gun on an open and extensive marsh, or in a forest would be required to use less circumspection and care, than if he were to do the same thing in an inhabited town, village or city. 8. Violation of rules and statutes. Statutes, administrative rules, and private rules of conduct. 9. Practice and custom. A practice which is dangerous to human life cannot ripen into a custom which will protect anyone who follows it. 10. Physical disability. General rule. A weak or accident-prone person must meet the standard of a reasonable man, otherwise he will be considered as negligent. Exception. If the defect amounts to a real disability, the standard of conduct is that of a reasonable person under like disability. The standard conduct of a blind person becomes that of a reasonable person who is blind. Case. Phoenix Construction vs. IAC. GR number L65295, 1987. At about 1:30 a.m. on November 15, 1975, private respondent Dionisio was on his way home from cocktails and dinner meeting with his boss. He was proceeding down General Lacuna Street when he saw a Ford dump truck parked askew, partly blocking the way of oncoming traffic, with no lights or early warning reflector devices. The truck was driven earlier by Armando Carbonell, a regular driver of the petitioner company. Dionisio tried to swerve his car to the left, but it was too late. He suffered some physical injuries and nervous breakdown. Dionisio filed an action for damages against Carbonell and Phoenix Insurance. Petitioners countered the claim by imputing the accident to respondent's own negligence in driving at high speed without curfew pass and headlights, and while intoxicated. Issue: whether Phoenix should be held liable for the damage incurred by Dionisio, notwithstanding the allegation that the latter had no curfew pass and thus drove speedily with his headlights off. Held: yes. The collision between the dump truck and the Dionisio's car would in all probability have not occurred had the dump truck not been parked askew without any warning lights or reflector devices. The improper parking of the dump truck created an unreasonable risk of injury for anyone driving down General Lacuna Street, and for having so created this risk, the truck driver must be held responsible. Bar question. Assumption of risk, 2015. X. A dressmaker, accepted clothing materials from Carla to make 2 dresses for her day. On the day X was supposed to deliver Carla's dresses, X called up Carla to say that she had an urgent matter to attend to and will deliver them the next day. That night, however, a robber broke into her shop and took everything including Carla's 2 dresses. X claims she is not liable to deliver Carla's dresses or to pay for the clothing materials, considering she herself was a victim of the robbery, which was a fortuitous event and over which she had no control. Do you agree? Why? Suggested answer: no, I do not agree with the contention of X. The law provides that except when it is otherwise declared by stipulation, or when the law provides, or the nature of the obligation requires the assumption of risk, no person shall be liable for those events which could not be foreseen or which, though foreseen, were inevitable. Article 1174. In the case presented, X cannot invoke fortuitous event as a defense because she had already incurred in delay at the time of the occurrence of the loss. Article 1165.
Number 5. Evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. In civil cases, the party having burden of proof must establish his case by a preponderance of evidence. General rule: a person claiming damages for the negligence of another has the burden of proving the existence of such fault or negligence causative thereof. The facts constitutive of negligence must be affirmatively established by competent evidence. Whosoever relies on negligence for his cause of action has the burden in the first instance of proving the existence of the same if contested, otherwise his action must fail. PLDT v. Court of Appeals. Exception: there are exceptional cases when the rules or the laws provide for cases when negligence is presumed. If negligence is not established, there can be no damages. Where it appears that an injury was received in an accident, without the intervention of negligence of any kind, no damages can be recovered by reason of such injury. Case: PLDT v. Court of Appeals. Facts: the Esteban's Jeep ran over a mound of earth and fell into an open trench, an excavation undertaken by PLDT for the installation of its underground conduit system. Esteban failed to notice the open trench, which was left uncovered because of the darkness and the lack of any warning light or signs. The Estebans allegedly sustained injuries. PLDT denies liability on the contention that the injuries sustained by respondent spouses were the result of their own negligence and that the entity which should be held responsible, BART, an independent contractor, which undertook the construction. Issues: whether PLDT is liable for the injuries sustained by the Estebans. Held: no. The accident which befell the Estebans was due to the lack of diligence of Esteban and was not imputable to negligent omission on the part of PLDT. The accident was not due to the absence of warning signs, but to the unexplained abrupt swerving of the Jeep from the inside lane. The Jeep was not running at 25 km an hour. At that speed, he could have braked the vehicle the moment it struck the accident mound. The Jeep must have been running quite fast. Esteban had not exercised the diligence of a good father of a family to avoid the accident. The negligence of Esteban was not only contributory but goes to the very cause of the occurrence of the accident, as one of its determining factors, and thereby precludes their right to recover damages. A person claiming damages for the negligence of another has the burden of proving the existence of such fault or negligence causative thereof. The facts constitutive of negligence must be affirmatively established by competent evidence. Whosoever relies on negligence for his cause of action has the burden in the first instance of proving the existence of the same if contested, otherwise his action must fail. Bar question. Burden of proof, 2009. Rommel's private car, while being driven by the regular family driver, Amado, hits a pedestrian causing the latter's death. Rommel is not in the car when the incident happened. Is Rommel liable for damages to the heirs of the deceased? Explain. Would your answer be the same if Rommel was in the car at the time of the accident? Explain. Suggested answer: a yes. Rommel may be held liable for damages if he fails to prove that he exercised the diligence of a good father of a family in selecting and supervising his family driver. The owner is presumed liable unless he proves the defense of diligence. If the driver was performing his assigned task when the incident happened, Rommel shall be solidarily liable with the driver. In case the driver is convicted of reckless imprudence and cannot pay the civil liability, Rommel is subsidiarily liable for the damages awarded against the driver and the defense of diligence is not available. B. Yes, my answer will be the same except that in such a case the liability of the owner is not presumed. When the owner is inside the vehicle, he becomes liable only when it is shown that he could have prevented the misfortune by the use of due diligence, Article 2184. For the owner to be held liable, the burden of proving that he could have prevented the misfortune rests on the shoulder of the victim. Presumption of negligence. What is a presumption of negligence? In tort law,
a principle that allows plaintiff to meet their burden of proof with what is in effect in circumstantial evidence. The plaintiff can create rebuttable presumption of negligence by the defendant by proving that the harm would not ordinarily have occurred without negligence, that the object that caused the harm was under the defendant's control, and that there are no other plausible explanations. Res ipsa loquitur. Res ipsa loquitur applies when a plaintiff who is injured in an accident does not know the precise cause of the accident and has to rely on the occurrence of the accident itself, as an event which does not happen in the ordinary course of things without the negligence, to infer negligence on the part of the defendant. Res ipsa loquitur literally means, things speak for itself. To prove res ipsa loquitur negligence, the plaintiff must prove three things. 1. The incident was of a type that does not generally happen without negligence. 2. It was caused by an instrumentality solely in defendant's control. 3. The plaintiff did not contribute to the cause. Limitations on res ipsa loquitur. And which injury which happens without the fault of a plaintiff, i.e. certain types of slip and fall accidents, would necessarily fail the prima facie test, failing the third element in particular. Sittie vs. Bigassa. GR number 149149, October 23, 2003. Facts. Bigassa and his three companions flagged down a passenger jeepney driven by Espina and owned by Pasuena. While respondent was boarding the passenger jeepney, his right foot already inside while his left foot still on the boarding step of the passenger jeepney, a truck driven by Sablayan and owned by petitioner Sittie bumped the rear end of the passenger jeepney. Respondent fell and fractured his left thigh bone. He also suffered lacerations and abrasions in his left leg. Respondent filed a complaint for damages for breach of common carrier's contractual obligations and quasi-delict against Pasuena, the owner of the passenger jeepney, herein petitioner Sittie, the owner of the truck, and Sablayan, the driver of the truck. Issue: whether petitioner had exercised the diligence of a good father of a family in the selection and supervision of his employee. Ruling: when an injury is caused by the negligence of an employee, a legal presumption instantly arises that the employer was negligent, either or both, in the selection and/or supervision of his employee. The said presumption may be rebutted only by a clear showing on the part of the employer that he had exercised the diligence of a good father of a family in the selection and supervision of his employee. If the employer successfully overcomes the legal presumption of negligence, he is relieved of liability. In other words, the burden of proof is on the employer. The failure of the defendant company to produce in court any record or other documentary proof tending to establish that it had exercised all the diligence of a good father of a family in the selection and supervision of its drivers and buses, notwithstanding the calls therefore by both the trial court and the opposing counsel, argues strongly against its pretensions. Bar Qs and As. Negligence arising from death of unborn child, 2003. If a pregnant woman passenger of a bus were to suffer an abortion following a vehicular accident due to the gross negligence of the bus driver, may she and her husband claim damages from the bus company for the death of their unborn child? Explain. Suggested answer: no, the spouses cannot recover actual damages in the form of indemnity for the loss of life of the unborn child. This is because the unborn child is not yet considered a person and the law allows indemnity only for loss of life of person. The mother, however, may recover damages for the bodily injury she suffered from the loss of the fetus, which is considered part of her internal organ. The parents may also recover damages for injuries that are inflicted directly upon them, e.g., moral damages for mental anguish that attended the loss of the unborn child. Since there is gross negligence, exemplary damages can also be recovered. Defenses to negligence claims. In several cases decided by the Supreme Court, the following are some of the defenses which have been interposed and were considered meritorious. Last clear chance. According to the doctrine, a person who has the last clear chance or opportunity of avoiding an accident, notwithstanding the act of his opponent or the negligence of a third person which is imputed to his opponent, is considered in law solely responsible for the consequences of the accident. For example, a pedestrian crosses the street even though the "Don't Walk" sign is clearly visible. A motorist who has the right of way but is distracted by her cell phone strikes and injures the pedestrian. Since the motorist could have avoided striking the pedestrian had she used ordinary care, she can still be found liable. Assumption of risk. Here the plaintiff, knowing the dangers involved, had voluntarily assumed the risk of injury and therefore foresee the impending harm that will result if he continues. When a plaintiff assumes the risk involved in an obviously dangerous activity but proceeds to engage in the activity anyway, he or she may not be able to recover damages for injuries. In order for this doctrine to apply, the plaintiff must have actual, subjective knowledge of the risk involved in the activity. An example might involve an amusement park ride that flips passengers completely upside down. A passenger who saw the ride and knew what would happen on the ride assumed the risks associated with the ride. On the other hand, a plaintiff does not assume the risk of something unexpected related to the ride, such as where a loose bolt causes the ride to throw the plaintiff in a violent manner. Prescription. A motion may be filed on the ground that the action on quasi-delict has already prescribed if such action has been filed after 4 years from the day the quasi-delict was committed. The prescriptive period is not interrupted by the filing of a criminal complaint, as the civil action is entirely independent of the criminal action. Contributory negligence. One of the most commonly used defenses to negligence claims is to show contributory negligence on the part of the plaintiff. Contributory negligence occurs when a plaintiff's conduct falls below a certain standard necessary for the plaintiff's protection, and this conduct cooperates with the defendant's negligence in causing harm to the plaintiff. In plain English, this means the plaintiff most likely would have avoided injuries had he or she not also been negligent. For example, a factory worker suffers serious burns to his face after his welding torch malfunctions. However, he failed to flip down his mask before using the torch, which would have prevented the injury. Comparative negligence. The doctrine of comparative negligence reduces a plaintiff's recovery by the percentage in which the plaintiff is at fault for his or her damages. The three main types of comparative negligence are: 1. Pure. Plaintiff is awarded a percentage of the damages for which defendant is responsible. 2. Modified. Plaintiff is awarded damages only if his or her negligence is equal to or less than the defendant's negligence. 3. Slight gross. Plaintiff is awarded damages only if his or her negligence is considered slight, and the defendant's negligence is gross. LBC Air Cargo vs. CA. GR number 101683. February 23, 1995. Facts. A certain Rogelio Monterola was riding his motorcycle along a dusty road when it collided with a cargo van owned by LBC Air Cargo driven by Jamie Tano Jr. coming from an opposite direction. On board the van was manager of LBC and his son. The van originally gave way to two almost racing cars which clouded the way of Tano, who then, not waiting for the dustiness to subside, turned sudden at the sharp curve, causing the mishap with the motorcycle, killing Monterola. Heirs of the latter filed for homicide through reckless imprudence, and damages were sought from LBC, the driver and the manager. Issue: whether LBC, Tano and the manager are liable for damages. Ruling: yes, but the manager is not, there being no employer-employee relationship between him and the driver. The proximate cause of the incident was Tano's negligence of not letting the dustiness subside and suddenly turning in the curve. LBC is liable as employer to Tano. However, Monterola contributed to the negligence because he was driving speedily and too closely behind the vehicle he was following, hence, damages are reduced by 20%. Bar Q's and Answer, 2003. As a result of a collision between the taxicab owned by A and another taxicab owned by B, X, a passenger of the first taxicab, was seriously injured. X later filed a criminal action against both drivers. May both taxicab owners raise the defense of due diligence in the selection and supervision of their drivers to be absolved from liability for damages to X? Reason. Suggested answer: it depends. If the civil action is based on a quasi-delict, the taxicab owners may raise the defense of diligence of a good father of a family in the selection and supervision of the driver. If the action against them is based on culpa, contractual or civil liability arising from a crime, they cannot raise the defense.
Special liability in particular activities. While any person may be liable for a quasi-delict or tort, the law has also identified specific individuals as being liable for particular types of injuries under certain conditions. Under torts, special liability is attached in certain and particular activities, primarily for the protection of the public. Products liability. Article 2187, Civil Code. Manufacturers and processors of foodstuffs, drinks, toilet articles and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no relation exists between them and the consumers. Under the foregoing provision, liability is not made to depend upon fault or negligence of the manufacturer or processor. The provision likewise dispensed with any contractual relation between the manufacturer and the consumer, thereby clearly implying that liability is imposed by law as a matter of public policy. Requisites of liability. 1. Defendant is a manufacturer or possessor of foodstuff, drinks, toilet articles and similar goods. 2. He used noxious or harmful substances in the manufacture or processing of the foodstuff, drinks or toilet articles consumed or used by the plaintiff. 3. Plaintiff's death or injury was caused by the product so consumed or used, and 4. The damages sustained and claimed by the plaintiff and the amount thereof. Burden of proof. The burden of proof that the product was in a defective condition at the time it left the hands of the manufacturer and particular seller is upon the injured plaintiff, who may recover. Although the article used the term consumer, such term includes a user and purchaser of the injuriously defective food product or toilet article. The person who may recover need not be the purchaser of the foodstuff or toilet article. Products Liability, Consumer Act. Coverage of the Consumer Act. The law covers consumer products and services which are defined in Art. 4Q as goods, services and credits, debts or obligations which are primarily for personal, family, household or agricultural purposes, which shall include but not limited to, food, drugs, cosmetics and devices. Basis of liability to consumers. 1. Fraud/misrepresentation. Article 50 of RA 7394 prohibits against deceptive sales acts or practices, while Art. 51 prohibits unfair or unconscionable sales acts or practices. However, not all expressions of opinion constitute misrepresentation. Usual exaggerations of trade under Article 1340, Civil Code or mere expressions of an opinion not made by an expert under Article 1341, Civil Code are strictly not actionable. 2. Warranty. A representation made by a seller is a warranty if he is an expert, and the buyer is induced to part with his money on the basis of this representation. The law on sales provides for implied warranties against hidden defects. 3. Negligence. Failure to meet safety and quality standards for consumer products, Art. 5-46 of RA 7394, creates liability based on negligence. It is the failure to observe the requisite due care considering the circumstances, governed by the provisions on quasi-delict. It has been said that the basis of products liability is the responsibility put upon one who sends goods out into the channels of trade for use by others. Product liability would thus appear to cover any liability of a manufacturer or other seller of a product where personal injury or damage to some other property is caused by a defect in the product, albeit product liability is generally not considered to cover instances where the product does not measure up to buyers' expectations, or on claims based merely on bad bargains. A manufacturer is strictly liable for torts when an article he places on the market, knowing that it is to be used without inspection for defect, proves to have a defect that causes injury to human being. This is also sometimes referred to as the enterprise liability. Although the doctrine has met with rapid and widespread acceptance, the doctrine relates only to defective and unreasonably dangerous products and does not make a manufacturer or seller and ensure that no injury will result from the use of his products, nor does the doctrine mean that such a manufacturer or seller is liable for any harm to anybody under the circumstances. Defective products. A product is defective when it does not offer the safety rightfully expected of it, taking relevant circumstances into consideration, including but not limited to a. Presentation of product. b. Use and hazards reasonably expected of it. c. The time it was put into circulation. A product is not considered defective because another better quality product has been placed in the market. The tradesman/seller is likewise liable, pursuant to the preceding article when A. It is not possible to identify the manufacturer, builder, producer, or importer. B. The product is supplied, without clear identification of the manufacturer, producer, builder, or importer. C. He does not adequately preserve perishable goods. Liability for product and service. Manufacturers and processors of foodstuffs, drinks, toilet articles and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. There is prima facie presumption of negligence on the part of the defendant if the death or injury results from his possession of dangerous weapons or substances. In the case of Coca-Cola Bottlers Philippines Incorporated versus the Honorable Court of Appeals, GR number 110295, October 18, 1993. Doctrine. The vendee's remedies against a vendor with respect to the warranties against hidden defects of or encumbrances upon the thing sold are not limited to those prescribed in Article 1567 of the Civil Code. The vendor could likewise be liable for quasi-delict under Article 2176 of the Civil Code, and an action based thereon may be brought by the vendee. While it may be true that the pre-existing contract between the parties may, as a general rule, bar the applicability of the law on quasi-delict, the liability may itself be deemed to arise from quasi-delict, i.e., the acts which breaks the contract may also be a quasi-delict. Facts of the case. Lydia Geronimo, the private respondent, filed a complaint for damages against petitioner with the Regional Trial Court, RTC, of Dagupan City. She alleged in her complaint that Coke and Sprite soft drinks sold by her contained fiber-like matter and other foreign substances or particles. The Department of Health later informed her that the samples she submitted are adulterated. Her sales of soft drinks plummeted from the usual 10 cases per day to as low as 2 to 3 cases per day as a result of the discovery of the foreign substances in the beverages, resulting in losses of between 200 pesos and 300 pesos per day, and not long after that she had to close shop on December 12, 1989. She became jobless and destitute. She demanded damages from the petitioner but was denied. Issue: whether the cause of action involved is quasi-delict. Ruling: yes. The public respondent's conclusion that the cause of action is founded on quasi-delict and that, therefore, pursuant to Article 1146 of the Civil Code, it prescribes in 4 years is supported by the allegations in the complaint, more particularly paragraph 12 thereof, which makes reference to the reckless and negligent manufacture of adulterated food items intended to be sold for public consumption. The vendee's remedies against a vendor with respect to the warranties against hidden defects of or encumbrances upon the thing sold are not limited to those prescribed in Article 1567 of the Civil Code. The vendor could likewise be liable for quasi-delict under Article 2176 of the Civil Code, and an action based thereon may be brought by the vendee. While it may be true that the pre-existing contract between the parties may, as a general rule, bar the applicability of the law on quasi-delict, the liability may itself be deemed to arise from quasi-delict, i.e., the acts which breaks the contract may also be a quasi-delict. Under American law, the liabilities of a manufacturer or seller of injury-causing products may be based on negligence, breach of warranty, tort, or other grounds such as fraud, deceit, or misrepresentation. Quasi-delict, as defined in Article 2176 of the Civil Code, is homologous but not identical to tort under the common law, which includes not only negligence, but also intentional criminal acts, such as assault and battery, false imprisonment and deceit. Mercury Drug Corporation v. Sebastian Baking. GR number 156037, May 28, 2007. Facts of the case. Respondent Sebastian Baking went to the clinic of Dr. Cesar Sy for a medical checkup. Subsequently, after several tests, Dr. Sy prescribed 2 medical prescriptions, Diamicron for his blood sugar and Benelise tablets for his triglyceride. Respondent then proceeded to petitioner Mercury Drug Store, MDC, to buy the prescribed medicines. However, The saleslady misread the prescription for diamicron for dormicron, a potent sleeping tablet. Unaware of the mistake, respondent took it for 3 consecutive days. On the 3rd day, he figured in a vehicular accident. His car collided with another car driven by one Josie Peralta. It turned out that respondent fell asleep while driving and has no idea regarding the accident. Suspecting that the tablet he took may have caused the accident, he returned to Dr. Sai and the latter was shocked because of the wrong medicine sold to his patient. Issue: whether or not petitioner was negligent, if so, whether such negligence was the proximate cause of respondent's accident? Ruling: yes. Article 2176 of the new Civil Code provides that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no re-existing contractual relation between the parties, is called a quasi-delict. The court also enumerated the three elements of quasi-delict, to wit: damage suffered by the plaintiff, fault or negligence of the defendant, connection of the cause and effect between the fault or negligence of the defendant and the damage incurred by the plaintiff. The court stressed that there is no dispute that respondent suffered damages. It is generally recognized that the drugstore business is imbued with public interest. The health and safety of the people will be put into jeopardy if the drugstore employees will not exercise the highest degree of care and diligence. That petitioner's employee was grossly negligent. The care required must be commensurate with the danger involved, and the skill employed must correspond with the superior knowledge of the business which the law demands. Hence, the court sustained that the proximate cause of the accident was the petitioner's employee's negligence. The vehicular accident could have not occurred had the employee been careful with his job. Bar question amp, suggested answer. 1976 Bar. X, a customer, drinks a bottle of soft drink in restaurant and is hospitalized due to harmful substance in the beverage. May the customer sue the manufacturer for the damages, although there is no contractual relation between the customer manufacturers? Suggested answer. Yes, the liability is based on tort. More specifically, Article 2187 provides that manufacturers and processors of foodstuff, drinks, toilet articles and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. It refers to the law which governs the liability of manufacturers and sellers for damages resulting from defective products. Presentation prepared by Carolyn Salcedo. Thank you for listening. Violation of rights by public officer. Article 34 of the Civil Code provides that when a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefor. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. What is city or municipal police force? They are law enforcement agencies that are under the control of local government. This includes the municipal government, where it is the smallest administrative subdivision. They receive funding from the city budget, and may have fewer legal powers than the state-paid police. What is independent civil action? An independent civil action is one that is brought distinctly and separately from a criminal case allowed for considerations of public policy, because the proof needed for civil cases is less than that required for criminal cases, but with the injunction in general that success in financially recovering in one case should prevent a recovery of damages in the other. It should be noted that the bringing of the independent civil action is permissive, not compulsory. The elements of Article 34 are: there is danger to the life or property of a person. A member of a city or municipal police force who is present in the scene refused or failed to render aid or protection to the person, and there are damages caused.
Liability in Article 34. On the part of the police officers, they are primarily liable for damages resulting in such cases. While the city or municipality, it is subsidiary liable. This article does not grant to the government the defense of due diligence in the selection and supervision of the policeman.
It is the duty of every police force to serve and protect every citizen, thus failure or refusal to render the said assistance can be a basis for claiming damages. Bar question: Lofranco was then the Commissioner of Internal Revenue while Fortune Tobacco Corporation is an entity engaged in the manufacture of different brands of cigarettes, among which are Champion, Hope, and more cigarettes. Fortune filed a complaint against Lofranco to recover damages for the alleged violation of its constitutional rights arising from Lofranco's issuance of Revenue Memorandum Circular No. 37/934, which reclassified Fortune cigarettes as locally manufactured with foreign brands and thereby imposed higher taxes, which the Supreme Court later declared invalid. Lofranco filed motion to dismiss, arguing that she cannot be held liable for damages for acts she performed while in the discharge of her duties as beer commissioner. Is she correct? Suggested answer: yes. As a general rule, a public officer is not liable for acts performed in the discharge of his duties. The exceptions are when he acted with malice, bad faith, or gross negligence in the performance of his duty, or when his act is in violation of a constitutional guaranteed right and liberties of a person under Article 3(2). The public officer is not automatically considered to have violated the rights or liberties of a person simply because the rule the public officer issued was declared invalid by the court. The complainant must still allege and prove the particular injury or prejudice he has suffered from the violation of his constitutional right by the issuance of the invalidated rule. The problem does not state any fact from which any malice, bad faith or gross negligence on the part of Lofranco may be inferred, or the particular injury or prejudice the complainant may have suffered as a result of the violation of his constitutional right. Hence, she cannot be held liable. Provinces, cities and municipalities. Article 2189 of the Civil Code provides that provinces, cities and municipalities shall be liable for damages for the death of, or injuries suffered by, any person by reason of the defective condition of roads, streets, bridges, public buildings, and other public works under their control or supervision. Jurisprudence provides that it is not even necessary that the defective roads or streets belong to the province, city or municipality for liability to attach. The article only requires that either control or supervision be exercised over said street or road. Lack of knowledge is not a defense. The LGU cannot be relieved of liability based on its purported lack of knowledge of the excavation and the condition of the road when the accident occurred. Its obligation to maintain the safe condition of the road within its territory is a continuing one, which is not suspended while a street is being repaired. Sources of municipal liability. Number 1. Liability arising from violation of law. Liability arising from violation of law such as closing municipal streets without indemnifying persons prejudiced thereby, non-payment of wages to its employees due to lack of funds or other causes, or its refusal to abide a temporary restraining order may result in contempt charge and fine. Number 2. Liability for contracts. LGU is liable provided that the contract is intra vires or it is ultra vires, that is only attended by irregularities, which does not preclude ratification or the application of the doctrine of estoppel. If it is ultra vires, which are entered into beyond the express, implied or inherent powers of the local government unit or do not comply with the substantive requirements of law, they are not liable. 3. Liability for tort. They may be held liable for torts arising from the performance of their private and proprietary functions under the principle of respondeat superior. City of Manila v. Genero Antiotico and C.A. The doctrine of the case. Under Article 2189 of the Civil Code, it is not necessary for the liability therein established to attach that the defective roads or streets belong to the province, city or municipality from which responsibility is exacted. What it requires is that the province, city or municipality have either control or supervision over said street or road. Facts of the case. The respondent, while waiting for a jeepney and as he stepped down from the curb to board the jeepney, and took a few steps, he fell inside an uncovered and unlighted catch basin or manhole on P. Burgos Avenue. Due to the fall, his head hit the rim of the manhole, breaking his eyeglasses and causing broken pieces thereof to pierce his left eyelid. As blood flowed therefrom, impairing his vision, Several persons came to his assistance and pulled him out of the manhole. One of them brought Tiatico to the Philippine General Hospital, where his injuries were treated, after which he was taken home. In addition to the lacerated wound in his left upper eyelid, Tiatico suffered contusions on the left thigh, the left upper arm, the right leg and the upper lip, apart from an abrasion on the right infrapatellar region. These injuries and the allergic eruptions caused by anti-tetanus injections administered to him in the hospital required further medical treatment by a private practitioner. The petitioner claimed that because of the incident, he was subjected to humiliation and ridicule by his business associates and friends. During the period of his treatment, plaintiff was under constant fear and anxiety for the welfare of his minor children since he was their only support. Due to the filing of this case, plaintiff has obligated himself to pay his counsel the sum of $2,000 aside from the loss of daily income. The respondent on the other hand said that the City of Manila cannot be held liable to Tiatico for damages, 1. because the accident involving him took place in a national highway, and 2. because the City of Manila has not been negligent in connection therewith. The issue of the case is whether or not the City of Manila is liable for said damages. Ruling: the court ruled on the positive. Article 2189 of the Civil Code of the Philippines provides that provinces, cities and municipalities shall be liable for damages for the death of, or injuries suffered by, any person by reason of the defective condition of roads, streets, bridges, public buildings, and other public works under their control or supervision. It is not necessary for the liability therein established to attach that the defective roads or streets belong to the province, city or municipality from which responsibility is exacted. What said article requires is that the province, city or municipality have either control or supervision over said street or road. It is outside of contention that the said city has control and supervision of the said street. Our question: the municipality of Pinatuctao is sued for damages arising from injuries sustained by a pedestrian who was hit by a glass pane that fell from a dilapidated window frame of the municipal hall. The municipality files a motion to dismiss the complaint, invoking state immunity from suit. Resolve the motion with reasons. The suggested answer is, the motion to dismiss should be denied. Under Section 2.4 of the Local Government Code and Article 2189 of the Civil Code, the municipality of Pinatuctao is liable for damages arising from injuries to person by reason of negligence of local government units or local officers of the defective condition of the municipal hall, which is under their control and supervision. Another bar question. A collision between a passenger jeepney, sand and gravel truck, and a dump truck driven by Monty and owned by the municipality of San Fernando occurred, which resulted to the death of Jessica, a passenger of the jeepney. The heirs of Jessica instituted an action for damages against the municipality. Is the municipality liable for the tort committed by its employee? The answer is no. The driver of the dump truck was performing duties or tasks pertaining to his office. He was on his way to get a load of sand and gravel for the repair of San Fernando's municipal streets. The municipality cannot be held liable for the tort committed by its regular employee, who was then engaged in the discharge of governmental functions. The death of the passenger tragic and deplorable, though it may be imposed on the municipality no duty to pay monetary compensation. And that's the end of my report. Thank you so much for listening. This has been Danica Mae Lofranco, saying stay safe and God bless.
Good evening, Dean. Good evening, classmates. This evening, I will be discussing about the violation by the owner of motor vehicle. So the relevant laws are the following. First law is Article 2184, which says in motor vehicle mishaps, the owner is solidarily liable with his driver if the former who was in the vehicle could have, by the use of due diligence, prevented the misfortune. It is disputably presumed that the driver was negligent if he had been found guilty of reckless driving or violating traffic regulations at least twice within the next preceding 2 months. If the owner was not in the motor vehicle, the provisions of Article 2180 are applicable. The second relevant law is Article 2186, which provides that every owner of a motor vehicle shall file with the proper government office a bond, executed by the government-controlled corporation or office, to answer for damages to third persons. The amount of the bond and other terms shall be fixed by the competent public official. So the owner is solidarily liable with the driver for motor vehicle mishaps when, first, the owner was in the vehicle at the time, and second, the owner could have by the use of due diligence prevented the misfortune. If the owner was not inside the vehicle, Article 2180 applies. The presumption is against the owner of the motor vehicle. He has the burden of proving due diligence. So the test of negligence is the omission of the person to do that which the evidence of his own senses tells him he should do in order to avoid accident. So once the driver is proven negligent in causing damage, the law presumes the vehicle owner equally negligent and imposes upon the latter the burden of proving proper selection and supervision of employee as a defense. So here are the relevant case laws. The first case is Vargas versus Langkay, where the Supreme Court held that the registered owner or operator of a passenger vehicle is jointly and severally liable for the driver for damages incurred by passengers or third persons as a consequence of injuries or death sustained in the operation of said vehicles. So regardless of who the actual owner of a vehicle is, the operator of record continues to be the operator of the vehicle as regards the public and third persons, and as such is directly and primarily responsible for the consequences incident to its operation. So that, in contemplation of law, such owner or operator of record is the employer of the driver, the actual operator, and employer being considered merely as his agent. So the second case is about the case of the Mayo versus Aquino. The Supreme Court said that the registered owner of a motor vehicle is primarily liable for the damage or injury caused to another, but he has a right to be indemnified by the real owner of the amount he was required to pay. This rule applies both to the private and to common carriers with respect to their passengers. So the relevant part question is, a Gallant driven by Chan and owned by Art and a Coral driven by its owner Gina collided somewhere along Adriatico Street. As a result of the accident, Gina had a concussion. Subsequently, Gina brought an action for damages against John and Art. There is no doubt that the collision is due to John's negligence. Question: can Art, who was in the vehicle at the time of the accident, be held solidarily liable with his driver John? Yes, Art may be held solidarily liable with John if it was proven that the former could have prevented the misfortune with the use of due diligence. According to Article 204, as discussed previously, in motor mishaps, the owner is solidarily liable with his driver if the former, who was in the vehicle, could have, by the use of diligence, prevented the misfortune. So the second topic is a violation by the proprietor of building or structure of thing. So the relevant laws are Article 2190, which says that the proprietor of a building or structure is responsible for the damages resulting from its total or partial collapse if it should be due to the lack of necessary repairs. Another relevant law is Article 2191. The proprietors shall also be responsible for damages caused, first, by the exclusion of machinery which has not been taken care of with due diligence and the inflammation of explosive substances which have not been kept in safe and adequate place. Second, by excessive smoke which may be harmful to persons or property. Third, by the falling of trees situated at or near highways or lanes, if not caused by force majeure. And last, by emanations from tubes, canals, sewers, or deposits of infectious matter, constructed without precautions suitable to the place. Under Article 2191, with the exception of number 1, negligence is not an issue. Next law is the Article 2192, which says that if damage referred to in the two preceding articles should be the result of any defect in the construction mentioned in Article 1723, the third person suffering damages may proceed only against the engineer or architecture or contractor in accordance with said article within the period therein fixed. So the ownership of building imposes on the proprietor thereof the duty to maintain it in good condition at all times, to the end that it may not collapse either totally or partially as to cause damage or injury to another's person or property. This duty obtains whether the building is leased or held in usufruct. Considering, however, that the lessee or usufructuary has direct and immediate control of the building, the law imposes on him the duty to notify the proprietor of such urgent and extraordinary repairs. Where the proprietor's failure to make the necessary repairs was due to the failure of the lessee or usufructuary to notify him, the proprietor is entitled to indemnification for damages he may have been required to pay to the parties. The plaintiff is required to prove, first, the total or partial collapse of a building or structure, that the defendant is the proprietor, that the collapse was due to the lack of necessary repairs. There is no requirement to prove negligence. Three are the relevant case laws. The first case is Gotesco Investment Corp. Versus Shadow. So the Supreme Court held that the owner or proprietor of a place of public amusement impliedly warrants that the premises, appliances, and amusement devices are safe for the purpose for which they are designed, the doctrine being subject to no other exception or qualification than that he does not contract against unknown defects not discoverable by ordinary or reasonable means. So let's proceed with the liability of engineer or architect of collapsed building. Article 73 provides that the engineer or architect who drew up the plans and specifications for a building is liable for damages if within 15 years from the completion of the structure the same should collapse by reason of a defect in those plans and specifications, or due to the defects in the ground. The contractor is likewise responsible for the damages if the edifice falls within the same period on account of defects in the construction or the use of materials of inferior quality furnished by him, or due to any violation of the terms of the contract. If the engineer or architect supervises the construction, he shall be solidarily liable with the contractor. Acceptance of the building after completion does not imply waiver of any of the cause of action by reason of any defect mentioned in the preceding paragraph. The action must be brought within 10 years following the collapse of the building. So the engineer or architect who drew up the plans and specifications is liable if the building collapses within 15 years due to, first, a defect in those plans and specifications, and last, is due to the defects in the ground. On the other hand, the contractor is liable if the edifice falls within 15 years due to, first, defects in the construction, second, the use of materials of inferior quality furnished by the contractor, and last, due to any violations of the term of the contract. Here, The plaintiff need only prove that such conditions or the defects exist and need not prove that negligence of the defendant be the cause of the conditions. So the relevant bar question is, Mr. and Mrs. R owned a burned-out building, the firewall of which collapsed and destroyed the shop occupied by the family of Mr. and Mrs. S, which resulted in injuries to said couple and the death of their daughter. Mr. and Mrs. S had been warned by Mr. and Mrs. R to vacate the shop in view of its proximity to the weakened wall, but the former failed to do so. Mr. and Mrs. S filed against Mr. and Mrs. R an action for recovery of damages the former suffered as a result of the collapse of the firewall. In defense, Mr. and Mrs. R rely on the doctrine of last clear chance, alleging that Mr. and Mrs. S had the last clear chance to avoid the accident if only they heeded the former's warning to vacate the shop, and therefore, Mr. and Mrs. R's prior negligence should be disregarded. Question: if you were the judge, how would you decide the case? Suggested answer was, I would decide in favor of Mr. and Mrs. S. The proprietor of a building or structure is responsible for the damages resulting from its total or partial collapse if it should be due to the lack of necessary repairs as according to Article 2190. And that ends my report.
Head of the family. The head of a family that lives in a building or a part thereof is responsible for damages caused by things thrown or falling from the same, Article 2193, Civil Code. In U.S. v. Topino 35 Phil 901, 1916, the husband was regarded as the head of the family, even in the fairly recent case of People v. Yamo, GR number 132138, January 28, 2000. It was said that in this culture, the father is called Halagi Ingtanan, the pillar of strength upon whom his children look for moral guidance and material as well as emotional support. The father is the padre de familia, the head of the family, who is morally and socially obligated to protect his family and to ensure their well-being. But under the family code, the management of the household is now the right and the duty of both spouses, Article 71. In the case of a family consisting of unmarried brothers or sisters, it seems that the head of the family is one on whom the family depends for lead support. Jose Dinkang vs. Halim Kanaan, Nasri Kanaan, and Michael Kanaan, engaged in commerce under the corporate name of American Bazaar, GR No. L 47033, April 25, 1941. Brothers Loreto Dinkang and Jose Dinkang established the Central Hotel where defendant Francisco Echevarria occupied as guest. The plaintiffs occupied the ground floor of this hotel where they had established their American Bazaar dedicated to the purchase and sale of articles and merchandise. One night, Echevarria, upon retiring to bed, carelessly left the faucet running on an ordinary basin without a drain as the pipes of the hotel at that time were under repair. An action was brought by Halim Kanaan, Nasri Kanaan and Michael Kanaan on behalf of American Bazaar against Loreto Dinkang, Jose Dinkang and Francisco Echevarria for damages caused to the plaintiffs. The court dismissed the case regarding Loreto Dinkang for having died, and sentenced Francisco Echevarria, acquitting Jose Dinkang. The Court of Appeals revoked the decision of the Court of First Instance and declared Jose Dinkang responsible and ordered him to pay the plaintiffs the amount of damages caused to them. Issue: whether or not petitioner is liable to pay damages. Ruling: being Jose Dinkang co-tenant and manager of the hotel, with full possession of the heights of the house, must respond for the damages caused by the things that were thrown or fell from it. Article 1910 of the Civil Code. Jose Dinkang did not practice the diligence of a good father of a family to prevent this damage, despite the fact that he knew that it could be caused by the fact that the pipes were then under repair, since, having to presume that Echevarria could use the tap, he did not provided some container with drainage, and if only put under it a basin that, when filled, under the law on quasi-delict, aside from the persons who caused injury to persons, who else are liable under the following circumstances. A. When a 7-year-old boy injures his playmate while playing with his father's rifle. Explain. Suggested answer. The parents of the 7-year-old boy who caused injury to his playmate are liable under Article 219 of the Family Code, in relation to Article 2180 of the Civil Code since they exercise parental authority over the person of the boy. Violations of data privacy. Data Privacy Act of 2012. RA 10173. Section 3. Definition of terms. G. Personal information refers to any information whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information would directly and certainly identify an individual. K. Privileged information refers to any and all forms of data which under the rules of court and other pertinent laws constitute privileged communication. L. Sensitive personal information refers to personal information. 1. About an individual's race, ethnic origin, marital status, age, color, and religious, philosophical or political affiliations. 2. About an individual's health, education, genetic or sexual life of a person, or to any proceeding for any offense committed or alleged to have been committed by such person, the disposal of such proceedings, or the sentence of any court in such proceedings. 3. Issued by government agencies peculiar to an individual which includes, but not limited to, social security numbers, previous or current health records, licenses, or its denials, suspension or revocation, and tax returns, and 4. Specifically established by an executive order or an act of Congress to be kept classified. Ronda Aves Viveres and SPS. Margarita and David Cesara vs. St. Teresa's College, Milan Riza T. Escudero, and John Does Gr. No. 200-2666 September 29, 2014. Nanita Julia V. Deluz, Julia, and Julien V. de Suzara, Julien, both minors, were graduating high school students at St. Teresa's College, STC, Cebu City. While changing into their swimsuits for a beach party they were about to attend, Julia and Julien, along with several others, took digital pictures of themselves only in their undergarments which were uploaded by Angela Lindsay Tan, Angela, on her Facebook profile. Milan Riza T. Escudero, a computer teacher at STC's high school department, learned from her students that some seniors at STC posted pictures online, depicting themselves from the waist up, dressed only in brasiers. Upon discovery, Escudero reported the matter and showed the photos to Christine Rose Tigal, STC's discipline in charge, for appropriate action. Senior Celeste Ma. Purisma P., Senior Purisma, STC's high school principal and ICM directress, informed their parents the following day that, as part of their penalty, they are barred from joining the commencement exercises. Angela's mother, Dr. Armenia M. Tan, filed a petition for injunction and damages and prayed that defendants be enjoined from implementing the sanction that precluded Angela from joining the commencement exercises. Petitioner Rhonda Avenue Viveres, the mother of Julia, joined as an intervener. The RTC issued a temporary restraining order, TRO, allowing the students to attend the graduation ceremony, to which STC filed a motion for reconsideration, but despite the issuance of the TRO, STC, nevertheless, barred the sanctioned students from participating in the graduation rites. Petitioners filed before the RTC a petition for the issuance of a writ of habeas data. The RTC dismissed the petition. Issue: whether or not there was indeed an actual or threatened violation of the right to privacy in the life, liberty, or security of the minors involved in this case. Ruling. In sum, there can be no quibbling that the images in question, or to be more precise, the photos of minor students scantily clad, are personal in nature, likely to affect, if indiscriminately circulated, the reputation of the minors enrolled in a conservative institution. However, the records are bereft of any evidence, other than bare assertions that they utilized Facebook's privacy settings to make the photos visible only to them or to a select few. Without proof that they placed the photograph subject of this case within the ambit of their protected zone of privacy, they cannot now insist that they have an expectation of privacy with respect to the photographs in question.